awakening and uprising prove unto thee, O Lord, sleep and darkness, our strength, safely brought, and our restorer to life and health. New every morning is thy love, awakening and uprising prove, through sleep and darkness, safely brought, restored to life and health and power. Our Heavenly Father, we give you heartfelt thanks today for the gift of life and the means to enjoy all your hands have provided. Thank you, O God, for the gift of your Son, Jesus Christ, through whom we have access to you by faith. As the National Assembly stands on the threshold of another day, Lord, we seek your individual and collective wisdom and grace and strength to carry out the task you have called the members to do and the nation to cooperate with this day. Thanks, O God, for your rich promises which come from a heart of love. Thanks for the assurance that your presence will go with us and to give us help. Lord, strengthen each one for the task and guide the National Assembly and the nation today as the members deliberate on the matters at hand. At the end, may your name be praised and your will be done in us today. When we return to our beds, Lord, may we look back and say, hitherto hath the Lord help us. These we pray in the name of our Lord and Savior Jesus Christ. Amen.
Thank you, Major Campbell. Good morning, everyone. Please be seated. As is the norm, first order of housekeeping is a reminder to turn all devices on silent and or vibrate for the duration of the sitting. Thank you. Next item.
Confirmation of minutes. Messages from the Governor General.
There are no messages from the Governor General.
Announcements by the Speaker.
There are no announcements this morning.
Presentation of papers and of reports from committees. Petitions. Government notices. Unofficial notices. Questions. Requests for leave to move the adjournment of the National Assembly on matters of urgent public importance. Statements by ministers. Personal explanations. Motions relating to the business of the National Assembly and moved by a minister. Introduction of bills and first reading.
I recognize the Honourable Member for St. Christopher 8.
Madam Speaker, I rise to seek your leave and to introduce and have read for the first time in this Honourable House a bill shortly entitled Smoking Designated Area Bill 2023.
Is there a seconder? I recognize the Honourable Member for St. Christopher 4.
Madam Speaker, I rise to second that motion.
The question is that the bill shortly entitled Smoking Designated Areas Bill 2023 be read a first time. Those in favor? Aye. Those against? The ayes have it.
A bill to designate certain specified public places as smoking areas, to prohibit smoking outside of a designated area in public places, to better provide for protection from exposure to certain types of smoke and for related or incidental matters, otherwise known as the Smoking Designated Areas Bill 2023.
The bill shortly entitled Smoking Designated Areas Bill 2023 has been read a first time. I recognize the Honourable Member for St. Christopher 8.
Thank you, Madam Speaker, and with your leave, once again, I rise to read and to have read and introduced for the first time a bill entitled Drugs Prevention and Abatement of the Misuse and Abuse of Drugs, Amendment Bill 2023.
Is there a seconder? I recognize the Honourable Senator Phillip.
Madam Speaker, I rise to second the bill shortly entitled Drugs Prevention and Abatement of the Misuse and Abuse of Drugs, Amendment Bill 2023.
The question is that the bill shortly entitled Drugs Prevention and Abatement of the Misuse and Abuse of Drugs, Amendment Bill 2023 be read a first time. Those in favor? Aye. Those against? The ayes have it.
A bill to amend the Drugs Prevention and Abatement of the Misuse and Abuse of Drugs Act, Cap 9.08, otherwise known as the Drugs Prevention and Abatement of the Misuse and Abuse of Drugs Amendment Bill 2023.
The bill shortly entitled Drugs Prevention and Abatement of the Misuse and Abuse of Drugs, Amendment Bill 2023 has been read a first time. I recognize the Honourable Member for St. Christopher 1.
Madam Speaker, I seek leave to introduce and have read for the very first time the Rastafari Rights Recognition Bill 2023.
Is there a seconder? I recognize the Honourable Member for St. Christopher 8.
Madam Speaker, I rise once again to second the motion.
The question is that the bill shortly entitled Rastafari Rights Recognition Bill 2023 be read a first time. Those in favor? Aye. Those against? The ayes have it.
A bill to provide for the process of registration of Rastafari groups, recognition of various rights related to the use of cannabis by registered Rastafari groups, licensing for the freedom of conscious possession and use of cannabis in certain public places, and for other related matters, otherwise known as the Rastafari Rights Recognition Bill 2023.
The bill shortly entitled Rastafari Rights Recognition Bill 2023 has been read first time. I recognize the Honourable Attorney General.
Madam Speaker, I rise to seek your leave and introduce and have read for the first time in this Honourable House the bill shortly titled Nevis Island Administration Civil Proceedings Bill 2023.
Is there a seconder? I recognize the Honourable Member for Nevis 9.
Madam Speaker, I've been afforded the privilege of seconding this bill and reserve my right, of course, to speak on the debate.
Very well. The question is that the bill shortly entitled Nevis Island Administration Civil Proceedings Bill 2023 be read a first time. Those in favor? Aye. Those against? The ayes have it.
A bill to provide for the Nevis Island Administration to sue and be sued in its capacity as an organ of the Crown and for related matters, otherwise known as the Nevis Island Administration Civil Proceedings Bill 2023.
The bill shortly entitled Nevis Island Administration Civil Proceedings Bill 2023 has been read first time. I recognize the Honourable Attorney General.
Madam Speaker, I rise again to seek your leave and introduce and have read for the first time in this Honourable House the bill shortly titled Crown Proceedings Amendment Bill 2023.
Is there a seconder? I recognize
Madam
the honourable
Speaker, I
member.
rise to
St.
second
Christopher
that
One.
motion before the Honourable House and reserve my rights to speak.
The question is that the bill shortly entitled Crown Proceedings Amendment Bill 2023 be read a first time. Those in favour? Those against? The ayes have it.
A bill to amend the Crown Proceedings Act, Cap 5.06, otherwise known as the Crown Proceedings Amendment Bill 2023.
The bill shortly entitled Crown Proceedings Amendment Bill 2023 has been read a first time. Recognize the Honourable Attorney General.
Madam Speaker, I rise to seek your leave to introduce and have read for the first time in this honourable House the bill shortly titled the Whistleblowers Protection Bill 2023.
Is there a seconder?
Madam Speaker, I rise with your leave to second the motion before this honourable House.
The bill shortly entitled Whistleblowers Protection Bill 2023. The question is, that the bill shortly entitled Whistleblowers Protection Bill 2023 be read a first time. Those in favour? Aye. Those against? The ayes have it.
A bill to deter and combat corruption and other improper conduct by encouraging and facilitating bona fide disclosures of such conduct and protecting the persons who make such disclosures, otherwise known as the Whistleblowers Protection Bill 2023.
The bill shortly entitled Whistleblowers Protection Bill 2023 has been read first time. I recognize the Honourable Attorney General.
Madam Speaker, I rise for the second to last time to seek your leave to introduce and have read for the first time in this honourable House the bill shortly titled Unauthorized Disclosure of Official Information Bill 2023.
Is there a seconder? I recognize the Honourable Member of St. Christopher 3, sorry.
Thank you.
Apologies.
Madam Speaker, I rise with your leave to second the motion before this honourable House.
The question is that the bill shortly entitled Unauthorized Disclosure of Official Information Bill 2023 be read a first time. Those in favour? Aye. Those against? The ayes have it.
A bill to deter and create penalties for unauthorized disclosure of official government information by public servants and contractors of the government, otherwise known as the Unauthorized Disclosure of Official Information Bill 2023.
The bill shortly entitled Unauthorized Disclosure of Official Information Bill 2023 has been read a first time. I recognize the Honourable Attorney General.
Madam Speaker, I rise ultimo tempore, as my late teacher would have said, who just passed this week, to introduce and have read for the first time in this honourable House Proceeds of Crime Amendment Bill 2023.
Is there a seconder? I recognize the Honourable Senator, Dr. Clark.
Madam Speaker, I second that motion.
The question is that the bill shortly entitled Proceeds of Crime Amendment Bill 2023 be read a first time. Those in favour? Aye. Those against? The ayes have it.
A bill to amend the Proceeds of Crime Act, Cap 4.28, and for related matters, otherwise known as the Proceeds of Crime Amendment Bill 2023.
The bill shortly entitled Proceeds of Crime Amendment Bill 2023 has been read a first time. Next item, please.
Public Business Bills, second reading.
Madam Speaker,
I recognize the Honourable Attorney General.
Madam Speaker, I rise to lead the debate of and have read for a second time in this honorable House the bill shortly titled Nevis Island Administration Civil Proceedings Bill 2023. Madam Speaker, the bill is short and simple. It is but one page on both sides, printed on both sides. However, Madam Speaker, it is an important bill as it was drafted as a collaborative effort between the Attorney General's office and the legal department of the Premier's office. Madam Speaker, despite its brevity, it is acutely and constitutionally important and involves the interaction of the three fundamental elements within our separation of powers configuration of government. The bill, Madam Speaker, seeks to fill a legislative gap identified in a judgment written by the Chief Justice of the Eastern Caribbean Supreme Court, Dame Janice Pereira, in a court case styled Nevis Island Administration versus Ocean Reef Resorts Limited. Madam Speaker, in effect, the judicial arm of government has adjudged that the executive arm of government has a limitation, which wasn't and therefore must be rectified by the legislative arm of government. This debate, therefore, Madam Speaker, is a perfect lesson for our people in the fundamentals of government and how the three branches of government can affect each other in a practical way. The bill, Madam Speaker, is also a precursor to the holistic constitutional enhancement exercise which the federal government and the Nevis Island Administration are about to embark on to tailor a robust constitution to guide our proud federation for another 40 years. The reason for the bill, Madam Speaker, is that in the NIA versus Ocean Reef Resorts Limited court case I referenced, Chief Justice Pereira issued a judgment which concluded that, and I quote, the NIA has no legal standing to sue and be sued in civil proceedings, given the applicability of the Crown Proceedings Act to Nevis, and further, that the proper party to Ocean Reef's claim and the proper party to be served in respect of the claim is the Attorney General of St. Kitts and Nevis, end quote. Note, Madam Speaker, that the federal government was in no way involved in the dispute between the NIA and Ocean Reef. However, the Chief Justice ruled that the federal parliament had no intention for the NIA to be clothed with legal standing to sue or be sued in civil proceedings. And that, I quote, the NIA is therefore part and parcel of the Crown for the purpose of the Crown Proceedings Act. Madam Speaker, this bill therefore seeks to directly fill the legal gap identified by the learned Chief Justice. Nothing more, nothing less. With your leave, Madam Speaker, I wish to read the three main provisions in the bill, which state, subject to Section 37(6), Chapter 10, and Schedule 5 of the Constitution, the Nevis Island Administration shall have the power to sue and be sued in its own name. All documents required to be served on the Nevis Island Administration for the purpose of or in connection with any civil proceedings against the Nevis Island Administration shall be served on the legal department of the Office of the Premier of the Nevis Island Administration. And lastly, all documents required to be served on an officer of the Nevis Island Administration, as distinct from the Nevis Island Administration itself, shall be served personally on that officer. As I said, Madam Speaker, this is a simple bill, but important and impactful. Since the judgment by the learned Chief Justice, lawsuits against the NIA have been served on the Attorney General's chambers in Bastille. We have been issuing fiats which are effectively formal orders of permission for NIA's legal department to take carriage of defending those lawsuits. For the benefit of the general public, I think it's important to address the constitutional and historical background which gave rise to this gap that the National Assembly is seeking to fill. Our independence constitution, which took effect on September 19, 1983, is the supreme law of St. Kitts and Nevis. And if any law is inconsistent with the Constitution shall prevail, and the other law shall, to the extent of the inconsistency, be void. The Crown Proceedings Act became law in June 1956 and was significantly amended in 1976. It is an act that provides for matters relating to the civil liabilities and rights of the Crown, and to provide for matters relating to civil proceedings by and against the Crown, etc. Civil proceedings are effectively legal disputes filed in court that are not criminal in nature. The key provisions of the Crown Proceedings Act state that civil proceedings against the Crown shall be instituted against the Attorney General, and all documents required to be served on the Crown for the purpose of or in connection with any civil proceedings by or against the Crown shall, where the proceedings by or against the Crown are brought in the name of an officer of the Crown, other than the Attorney General, be served on that officer or on the Attorney General. That is how the structure was since 1956. Historically, the Crown, otherwise known as the state, was Nevis and St. Kitts together. Pre-independence, Nevis did not have any legal status separate from the single state of both islands. Nevis relied on the only government, headquartered in Bastille. It is for this reason the crafters of the Constitution, within the political landscape of the day, sought to create a legal structure so that Nevis had some autonomy over its own affairs. The Constitution therefore created the Nevis Island Administration. It is firmly a legal creature with judicial standing, sanctioned by the highest law of this land. However, without specific provisions in the Constitution that allow the NIA to sue and be sued, and the Crown Proceedings Act being drafted at a time when there was a singular state made up of three islands at that time, there was room for an interpretation that there was no legal permission for the NIA to sue and be sued separate from the single state. The bill tabled today seeks to plug that gap. Of note, Madam Speaker, if you allow me to diverge a bit to inform our people that we are not alone in this world in the styling of our two-island federation structure. There is a similar, yet not identical, structure in Africa. The United Republic of Tanzania, made up of mainland Tanzania and the group of islands known as Zanzibar, is a unitary state based on a multi-party parliamentary democracy. All matters of state in the United Republic of Tanzania are exercised and controlled by the government of the United Republic of Tanzania and the revolutionary government of Zanzibar. Federal government of St. Kitts and Nevis, United Republic of Tanzania, Nevis Island Administration, revolutionary government of Zanzibar. The government of the United Republic of Tanzania has authority over all union matters in the United Republic as stipulated under their constitution. And it also runs all non-union matters on mainland Tanzania, the territory formerly known as Tanganyika. I hope I'm not slaughtering that name. The revolutionary government, equivalent to the NIA, administers everything else. For clarity, Madam Speaker, the union matters in their constitution are the constitution itself, foreign affairs, defense and security, police, emergency powers, citizenship, immigration. Sounds familiar, Madam Speaker? service in the government of the United Republic, income tax payable by individuals and by corporations, customs duty, excise duty on goods manufactured in Tanzania, collected by the Customs Department, harbors, matters relating to air transport, ports, telecommunications, matters concerning coinage and currency for the purposes of legal tender, banks, banking business, foreign exchange and exchange control, industrial licensing and statistics, higher education, mineral oil resources, including crude oil, National Examinations Council, civil aviation research, meteorology, statistics, the Court of Appeal of the United Republic, and registration of political parties and other matters related to political parties. That is the federal responsibilities of that state. Everything else is dealt by the equivalent of the NIA. Madam Speaker, in St. Kitts and Nevis, Section 106(1) of the Constitution states that the NIA shall have exclusive responsibility for the administration within the island of Nevis in accordance with the provisions of any relevant laws of the following matters: airports and seaports, education, extraction and processing of minerals, fisheries, health and welfare, labor, land and buildings vested in the Crown and specifically appropriated to the use of the government, licensing of imports and exports out of St. Christopher and Nevis. I sense that the Premier's brain is working, thinking about the impending constitutional negotiations for there to be potentially a federal list, and Nevis gets to control everything else, like in Tanzania. Honorable Premier, please note that the Constitution of that nation states, the government of the United Republic shall maintain a special account to be known as the Joint Finance Account, and which shall form part of the Consolidated Fund of the United Republic, into which shall be paid all the monies contributed by the two governments in such proportions as shall be determined by the Joint Finance Commission in accordance with a law enacted by Parliament for the purposes of the business of the United Republic in relation to union matters. That is how they dealt with their share of revenue. They, and I quote, continue to quote, there is hereby established a Joint Finance Commission consisting of not more than 7 members who shall be appointed by the President in accordance with this article and the provisions of a law enacted by Parliament. The functions of the Commission shall be to analyze the revenue and expenditure arising from or relating to the management of affairs concerning union matters, and to make recommendations to the two governments concerning the contribution by and the allocation to each of the governments. To keep under constant scrutiny the fiscal system of the United Republic and also the relations between the two governments in relation to financial matters. To discharge other functions which the President shall assign to the Commission, or as the President may direct in accordance with the law enacted by Parliament. Isn't that an interesting system, Madam Speaker? Madam Speaker, I say all of that to say that when the Joint Constitutional Review Committee that is being set up by the Prime Minister is expanded and moves to the next phase of holistic reform of our Constitution, we won't have to reinvent the wheel. There are international and regional examples we can examine to create the best bespoke constitutional solutions in the best interests of the people of St. Kitts and Nevis and our body politic. With respect to the reasons for the bill, Madam Speaker, it is arguable that the framers of our Constitution, when allocating matters within the exclusive domain of the NIA, simply forgot to expressly include the NIA's ability to sue and be sued. It is similarly arguable that that right didn't need to be expressed in writing, but it was inherently understood that the Crown Proceedings Act would be read subject to the Constitution, the NIA being an express arm of the Crown in the Constitution. On whichever side of that argument one falls, it's our duty as legislators to find the solution. We firmly believe that the Nevis Island Administration Civil Proceedings Bill 2023 is that solution, and we humbly wish its safe passage and the support of the entire National Assembly, but at least 2/3 of the elected members of this august body. The reason I said 2/3, Madam Speaker, is because Section 37(6) of the Constitution which provides that Parliament may make additions to the matters specified in Section 106(1). But the bill for that purpose shall not be regarded as being passed in the National Assembly unless, on its final reading, it is supported by the votes of not less than 2/3 of all of the representatives. Whilst granting the NIA the ability to sue and be sued seems an inherent status of a constitutionally established entity, out of an abundance of caution, and to avoid any potential legal challenges which could arise in this litigious society of ours, the Attorney General's Office and the Legal Department of the NIA felt it necessary to ensure that this bill receives a 2/3 majority, contemplated by Section 37(6). That means the support of at least 8 of the 11 elected members. Madam Speaker, as I said when I started, it is a very simple, very short and simple bill, but very important. And with those few words and explanations for the bill, Madam Speaker, with your leave, I'd like to take my seat.
Thank you to the Honorable Attorney General, mover of the bill. I recognize the Honorable Member for Nevis 9.
Madam Speaker, I rise following on the very useful submissions of the Honorable Attorney General to lend my support to what I believe is a critically important piece of legislation, the Nevis Island Administration Civil Proceedings Bill 2023. He has, in a very erudite way, explained why we are here. But if I can take a moment just to provide some context or further context for the public, and to say this, that the Nevis Island Administration is a creature of statute. And it is a creature of, forgive me, let me start again. The Nevis Island Administration is a creature of the Constitution. And that Constitution, as we have heard, dates back to 1983. And therefore, the Nevis Island Administration, and I believe all who understand and have worked with the Nevis Island Administration, the public sector and the private sector, have accepted, as a matter of course, that the Nevis Island Administration has the power to sue and be sued. In fact, Madam Speaker, at Section 106 of the Constitution, which by its own terms is a supreme law of St. Kitts and Nevis, it makes it abundantly clear, and I quote from Section 106, the administration, meaning the Nevis Island Administration, shall have exclusive responsibility for the administration within the island of Nevis in accordance with the provisions of any relevant laws of the following matters: airports and seaports, education, extraction and processing of minerals, fisheries, health and welfare, labor, land and buildings, vested in the Crown, licensing of imports. I believe it is important that the public and the Parliament are aware that Section 106 grants exclusive responsibility. And I agree entirely with one of the positions put forward by the Honorable Attorney General, that it would seem obvious that if you have exclusive responsibility for something, then part and parcel of that exclusive responsibility has to be the ability to sue and be sued. Let me use a practical example, Madam Speaker. The Constitution, the Supreme Law, gives the NIA, Nevis Island Administration, exclusive responsibility for airports on Nevis. Let us say that the NIA, in the exercise of that exclusive responsibility, enters into some contractual arrangement in relation to the airport. one would expect that it has that authority, and naturally arising from that contractual commitment, it has the authority to sue or be sued under that contract. It follows, and it is said that things that are obvious need not be expressed. It also, under our Constitution, we have that notion of it being the primary law in the country. It is the standard against which all other laws are measured. Basic Constitutional Law 101. That any law that comes into conflict with our Constitution is void. And we have what is referred to as a pro tanto effect. Simply means that if it's not void in its entirety, it's void to the extent that it conflicts with the Constitution. So the starting place always is the Constitution. Now, why have I bothered to perhaps state the obvious? I have bothered to state the obvious because for years, the Nevis Island administration has sued and has been sued. And there was never an issue. Throughout all these 40 years of independence, there has never been an issue of the NIA suing or being sued. I have this morning gone to the Eastern Caribbean Supreme Court website where judgments are settled. I see a judgment there dating back to 2006, 3rd of April, in the matter of the Nevis Island Administration against La Propriété du Navire et al., a case that I myself was involved in when I was young. And that was a matter that went all the way to the Court of Appeal. No issue. In fact, the decision from the Court of Appeal, the single judge, Justice of Appeal Barrow, as he then was, he's now at the CCJ, Caribbean Court of Justice. That decision has become the leading decision in the region on the issue of relief from sanctions. It's been cited everywhere. Who was the party? The Nevis Island Administration. Went all the way to the Court of Appeal. Cited in every textbook as the primary case, the seminal case on the issue of relief from sanctions. No dispute as to the legal standing and ability of the NIA. That was in 2006. I found another decision, Choice FM, against the Nevis Island Administration. A decision of Master Fidela Lincoln. What did that deal with? Breach of contract and damages, civil matters. That was a decision delivered 14th of April 2016. No issue. I went again. I found Wingrove Wilkerson and the Nevis Island Administration. Delivered 17th of February 2020. Just 3 years ago. A decision of Mr. Justice Ventos, and that was a claim in damages for negligence. Again, a civil matter. I use these 3 decisions because I'm pretty sure if I continue to search, I would find countless others. But I use them to demonstrate that the issue of the standing of Nevis and the Nevis Island Administration to sue or be sued was never, ever in question. It therefore came as some surprise that in a matter Ocean Reef Resorts Limited and the NIA, that the Court of Appeal, in a decision delivered, I believe it was in August of 2022, August 17th to be precise, that the Chief Justice, Madam Justice Pereira, with whom her colleagues on the full court, Mario Michel, Justice of Appeal, and Gerard Ferrara, KC, Justice of Appeal, acting, agreed that the NIA had no standing to sue or be sued in civil matters. That took everybody by surprise because it turned the law as we knew it for all these years on its head, and it introduced novel considerations that had not hitherto occupied our minds. Madam Speaker, I believe that it is relevant for me to point out that the issue of the juridical nature of the NIA and its ability to sue or be sued was not a live issue in this case. This case involved a simple question of a default judgment that had been entered by Ocean Reefs against the NIA and whether or not that default judgment should be set aside. That was the issue. The learned Chief Justice in the Court of Appeal made the determination that the court wanted to look at this discrete issue of the authority of the NIA to sue or be sued, and invited counsel to make submissions. I'm advised, and based on the judgment, that counsel in that matter, Mr. Terence Byron, assisted by Rhonda Niswick Brown for the NIA, Dr. Henry Brown KC for, I imagine it was Ocean Reefs, and the Attorney General was represented by Mrs. Simone Bullen Thompson, who is our Solicitor General. Now I want the Parliament and the public to understand that this issue never rose on the face of the proceedings, and therefore one may argue was not necessary for it to be determined in order to answer the question that was actually before the court. The court decided it wanted to examine this issue, invited submissions from counsel. And what is interesting is that all counsel agreed that the NIA had standing to sue and be sued. All. So on all sides of the issue, there was consensus from the lawyers that the NIA had standing to sue and be sued. And one could understand that because I've just listed just 3 authorities to you, going as high as the Court of Appeal, where that issue was moot. It was never even a contemplation. And so, again, one could understand the surprise that the Court of Appeal opted to ignore all that had gone before, ignore decisions in which the NIA had been involved as a litigant, decisions from the very Court of Appeal, and ignore the submissions of all counsel before the court on the Ocean Reefs matter on this discrete point, and then came up with its own decision. And that decision was that the NIA had no authority. I thought it was interesting to look a bit at the judgment, again, to give context as to why we're here. Paragraph 13, Court of Appeal acknowledges that Section 106 of the Constitution outlines the matters for which the NIA has exclusive responsibility. And I have referred to those at the beginning of my short speech to the Parliament today. In paragraph 16, the Chief Justice, speaking for the full court, opines that there is nothing in Section 106 of the Constitution which imbues the NIA with legal standing to sue or be sued in respect of land and buildings vested in the Crown, or indeed in respect of any other area of exclusive responsibility. Now, that is an interesting observation, because it means, on the one hand, you're giving a man exclusive responsibility in his home, but on the other hand, you tell him if anything goes wrong, you must come to Basti and find the AG and beg the AG to bring action for you. Well, that doesn't look like exclusive responsibility to me. It's an odd conclusion. And I hasten to say that I'm looking at the judgment, not criticizing the court, of course. But it is a curious conclusion to arrive at, that the supreme law gives exclusive responsibility for a matter. But the court then, having not been invited to opine on it, decides to opine on it and determines that exclusive doesn't really mean exclusive. And the curiosity is further compounded, because if this decision is taken to its logical conclusion, it means, as the Honorable Attorney General has pointed out, that the federal government and the Office of the Attorney General can be dragged into matters of which they know nothing. Because the NIAs in Nevis operating on 106 of the Constitution, saying that they have exclusive authority in these areas, making decisions, cabinet is meeting and deciding this is what we're going to do. And then when something goes wrong, the Attorney General's office gets sued. And the Attorney General says, well, what is this? I don't know anything about this. I've never heard of this matter. That is what has been created by the Court of Appeal decision. So you had a situation which for decades worked well, no issues. And then the Court of Appeal intervened, and this is now the result. And see what the Attorney General has said. People now agree with the NIA, who decide they're going to sue the NIA. Nevis now has to come to Bar State for fiat, and all fiat means a big word to mean permission, from the Attorney General. How then is that exclusive or responsibility on the part of the NIA? Now, it's not for me to suggest what should have happened in the Court of Appeal. But there is a notion, harking back to my years in law school, that talks about judicial restraint in relation to constitutional matters. And if I understand that doctrine, it suggests that where something is not necessary, then the courts generally would shy away from making profound statements on matters that are not necessarily before them. And I am not certain that the Court of Appeal really understood the chaos that could ensue from this judgment. For example, the NIA borrows money. In fact, we owe National Bank and those banks a lot of money. What if tomorrow we said, well, we can't be sued and we can't sue? National Bank, we're not paying. What National Bank going to do? Sue the AG? And when they sue the AG and they get judgment, who going to pay? The NIA? But we know about the AG, we didn't instruct the AG. These are some of the practical matters. The NIA employs people. We have a whole public service in Nevis that is employed by the NIA. Thousands of people. If one of them has an issue with the Nevis Island administration as their employer, you're telling them they must come back still to sue the AG? The AG don't know about them. They're not employed to the federal government. This is the whole horse and buggy that was run through the Constitution by this decision. And that is why I'm persuaded that the court did not take into account the implications of what it was saying. And in essentially overruling decades of authority, it did not contemplate, well, what does this mean for the functioning day-to-day of the Nevis Island administration? And what does it mean for the federal government and the Attorney General? In essence, this is telling me that before I as Premier could take a decision to employ somebody or to issue a contract in Nevis, I should call the AG. I should discuss, AG, here's what I want to do. AG, if something goes wrong, is you they're going to sue? The AG has every right to say, well, you're not paying me. Why should I be taking instructions from you, Premier? You have a legal advisor in Nevis. That's the chaos that I talk about and has been created by this decision. Now, what then is this legislation seeking to do? This legislation is really seeking to correct the mischief that has now been created in terms of the practical and legal implications of this judgment. And in a real way to restore us to what was prior to the, when did I say the judgment was? August 17th, 2022. It's less than a year ago. So prior to August 17, 2022, we had an established, well-known, well-respected approach to these matters. And this legislation, therefore, seeks to reset and really to put us back to what was and what had always been accepted. Now, one would have thought, Madam Speaker, that if there was a contest between the clear implication of the Constitution through 106, which, as we recall, is a supreme law, and any other law inconsistent with it is void to the extent of the inconsistency. One would have thought that if the Crown Proceedings Act was then to be measured as against the Constitution, if any one of them had to give way, it must have been the Crown Proceedings Act. And it therefore would have been open to the court to say, the Constitution does not make us express provision that the NIA has the power to sue and be sued in civil proceedings. However, it follows as a matter of course, as a matter of logic, as a matter of necessity, that it has that authority. It also follows the course of years and years, decades of jurisprudence on the matter. That is what one would have expected. And therefore, if there was a perceived conflict between that and the Crown Proceedings Act, the Crown Proceedings Act is ordinary legislation. It is the Crown Proceedings Act which should have given way, not the Constitution. We should not have been told that the Constitution must be amended or something must be done. It is the Crown Proceedings Act which should have been found to be deficient. And I'm happy that the history of the Crown Proceedings Act has been given today. Because what it says is that the Crown Proceedings Act predated the Constitution. It therefore means that when the framers of the Constitution put that document together in 1983, that the Crown Proceedings Act was already in existence. It therefore has to be read subject to the Constitution and the Supreme Law, not the Constitution read subject to the Crown Proceedings Act. That is put in the cart before the horse. And one would have thought that these considerations would have impacted the Court of Appeal. But we are where we are. We have a decision, and the only way to remedy this situation, one, was to go to the Privy Council and to invite the law lords in London to set aside this decision, to say to them that the Court of Appeal fell into error, some may say egregiously so, and that they ought to set the matter right. The other option is to do what we are doing today, to come to the Parliament and to seek, by way of amendment, to make it clear that the NIA has the power to sue and be sued. And that, Madam Speaker, is why we are here. Madam Speaker, the choice then was further appeal to Her Majesty in Council, His Majesty in Council, forgive me, Privy Council, or through legislative amendments. We have come, therefore, via the route of legislative amendment. And the provision, the legislation that is proposed is the Nevis Island Administration Civil Proceedings Bill 2023. The Honorable Attorney General has taken us through the provisions, and I don't think that any value is added through repetition. But the important aspect of that is to answer two fundamental questions. One, whether the NIA, Nevis Island Administration, can sue and be sued in civil proceedings, and this seeks to answer that question in the affirmative, to say, yes, it can be done. In fact, at Section 3, it says the Nevis Island Administration shall have the power to sue and be sued in its own name. One would have thought it was trite law, but belts and braces. We're trying now to make it, as they say, ex abundante cautela, out of an abundance of caution. We're saying that it should now be a matter of substantive statutory law. And then the second question was the service of documents, which really was the question that arose in the Ocean Reefs decision, you know. the Ocean Reefs decision case issue was all about whether the documents had been properly served. The Court of Appeal did not have to go any further than that. They just had to say, yeah or nay. That really was the issue. Instead of that, we had a whole constitutional exposition, which resulted in a near constitutional crisis in my view as to how this country functions and how the two entities function. So, this law, this legislation, deals substantively with those two issues. Can the NIA sue and be sued? Yes. And who will you serve when you sue the NIA? And it tells you. You serve the legal department, or where an officer is named, you serve that officer. Simple, clean, and hopefully final. And I want to go on record to thank the Honorable Attorney General, because his office and the legal department in Nevis will have worked collaboratively to come to a solution and to come to a resolution, might be the better word, of this issue, to extricate the office of the Attorney General from matters really and truly which has nothing to do with the office of the Attorney General, and to ensure that the Nevis Island administration has now the express authority from what one would have expected to have been implied, that if you have exclusive responsibility, then you must have the authority to enforce that and sue or be sued. And as I have already pointed out, the practical implications of doing otherwise would really be disastrous in terms of how we function, both at the federal level and at the level of the Nevis Island administration. Now, I know that there is another bill to come, but again, that will come when it comes, the Crown Proceedings Amendment Bill, and that again is just for the belts and braces, Madam Speaker, to make sure that we put this issue beyond doubt. I should also add that this decision has created a lot of confusion on the island of Nevis. It has stymied in a very real way the ability of the NIA to function. It has brought into question contractual commitments and obligations that the NIA has incurred. It has raised the fundamental issue of whether the NIA itself can go to court to enforce certain contracts and commitments. It has raised, as I pointed out, the issue of our debt and how that debt is to be addressed. And so there are fundamental practical reasons why we had to come today. Some may say that we have come too long after the fact, but I say we have come when the legislation is ready, and that we are satisfied that we are now here and we have to address this, and to address this in a direct way. The Honorable Attorney General raised an overarching point, and that has to do, of course, with the proposed constitutional review that will happen. And he's absolutely correct that we are hopeful that after 4 decades of talk, that we would finally have an opportunity to revisit the 1983 Constitution of St. Christopher and Nevis, and to determine what, if any, changes should be made, what, if any, clarity is necessary. He cites, I believe, an example in Tanzania. The only thing I didn't like about it, he said that the government is a revolutionary government. I want to make it clear that the NIA is not a revolutionary government. But these are examples which I think are useful in looking across the landscape of the world, looking across our region, seeing best practices, and when we get to that point where the consultations start, to really see how we can incorporate those best practices. But I want to end by saying to our public that we ought not to be overly dismayed when we are confronted with decisions from the court or otherwise which seek to define areas that had hitherto been assumed or undefined. And the reason I say that is because, again, as the Honorable Mover has pointed out, we have that separation of powers where the courts have the right, we may not always agree with their decision, but they have the right, undoubtedly so, to interpret. And it is true, and I believe the Chief Justice said so in that Ocean Reefs decision, that because you've been doing something all along doesn't make it legally proper. So we accept that. And that is why I think that the public should, when these types of matters come up, actually have some comfort, notwithstanding the chaos and the confusion that the decision might have created for the interaction of the NIA and the federal government and the standing of the NIA to sue or be sued. I think the public should have some comfort that our constitutional mechanisms are in fact working. And that if the court points out a lacuna, whether we agree that there was a lacuna or not, the Parliament has the ability to come here and legislate to fill that lacuna. And that is how mature democracies function. That is how we balance the competing jurisdictions, if you will, of the various branches of government. And so the judiciary says to us that there's a lacuna. We may agree or we may disagree. But the Constitution itself allows us to come here, as we're doing today, to fix the problem. And that, I think, ought to be a lesson for all of those students of constitutional law and theory, for all of those who study government and good governance. That should be a lesson. Because we don't have to go out there and start to cuss the judge and cuss the court and say all manner of things. You see, I tell you, we had the option. Go to the Higher Court of Appeal in England, or come here. The Attorney General, in his wisdom, talking to the legal department in Nevis in their wisdom, they decided they will come here. And this, I believe, is a good demonstration of a mature democracy at work. And so, notwithstanding the challenges, and notwithstanding, as you could tell, my own strong disagreement with this decision, it is yet another example of a democracy which is maturing, and a democracy that I believe we should be proud of. Because at the end of the day, it is not that problems will not arise, problems will arise. This problem arose out of nowhere. We never expected it. But the Constitution and our democratic traditions allow us a formula to solve problems without resorting to any type of untoward or unwarranted activity. And I believe that that is a good lesson for today. So, I perhaps have said more than I needed to, but I wanted, Madam Speaker, to set the tone in a way, pick up from where the Honorable Attorney General left off, and to say that today is a good day, because today we are seeking to solve a problem and put the matter beyond doubt, which brings comfort to all of those who have dealings with the Nevis Island administration, that if for some reason things were to go right, that the fundamental power and authority to sue and be sued has now been preserved. And it is my hope that if anybody were to cite the Ocean Reefs decision to any court, that counsel on the other side would cite the Nevis Island Administration Civil Proceedings Act when it is enacted. I'm, of course, asking for the 2/3, and again, that's belts and braces. We've had a debate as to whether or not it's really necessary, but I'm asking my colleagues on this side to say aye, and obviously the government side, I'm hopeful, would say aye. Some of them claim roots in Nevis, so I believe they'll understand and say aye, because we really would like to see this matter put to bed and the position clarified moving forward. Because every country, every island, every government needs a legal certainty in order to engage and to do business. Thank you very much, Madam Speaker.
Thank you to the Honourable Member for Nevis 9. I recognize the Honourable Senator Jones.
Madam Speaker, with your permission, I rise to give my presentation and to offer my support to this very important bill, the Nevis Island Administration Civil Proceedings Bill 2023. Madam Speaker, I would first like to commend the Attorney General for tabling this bill today. This bill is very important as it will protect the image and provide a clearer understanding of the Nevis Island Administration's authority to govern the affairs of the island of Nevis. This bill will address the questions and concerns raised by the residents of Nevis, the wider Federation, and judiciaries about the legal standing and the autonomy of the Nevis Island Administration. Madam Speaker, the decision passed by the Appeal Court in 2022 had great implications for the internal autonomy of Nevis. That decision, to my mind, rolled back or reversed the autonomy which we enjoyed for some 40 years. Madam Speaker, the reversal or rolling back of autonomy has created much tension, animosity, and even conflict throughout the world. In recent years, several conflicts have centered on the demands for autonomy. Equally, tensions and conflicts have been diffused and resolved by the concession of autonomy. History has shown us that whenever internal autonomy was rejected, cancelled, or neglected by a greater or dominating power, a conflict often results. We see this in Hong Kong when China reversed the autonomy to which they were accustomed. Shortly after handing over of Hong Kong by the United Kingdom to China on 1st July 1997, China proclaimed one country, two system policy to pacify and appease the people of Hong Kong and the world. However, this was all a ruse. China soon began to reverse and erode Hong Kong's autonomy. Since then, the pro-democracy protest has become stable. Madam Speaker, we can also look at the conflicts in Syria, the rebellion in Mali, the separatist movement in Catalonia, Spain, and the list can go on. All these conflicts originated with the reversal of autonomy. Madam Speaker, the court's decision could have easily been construed or misconstrued by some as a reversal of autonomy for Nevis. However, unlike other countries in the world where conflict is often the result, we are present at this sitting to remedy the situation legislatively. For this, I commend the federal government and the mover of the bill for their understanding and graciousness. Madam Speaker, for 40 years, the Nevis Island Administration has governed the island of Nevis. The administration has entered into contractual agreements and has been sued in respect of land and building vested in the Crown and other areas of exclusive responsibility. The NIA's legal standing was not legally questioned until 2022. Constitutionally and by convention, it was always accepted that the Nevis Island administration had the right to sue or be sued. Madam Speaker, I will not second guess or cast aspersions on the court's decision. Instead, I will commend the Attorney General, the legal department in Nevis, for providing a solution in a timely manner. The passing of this bill will only serve to strengthen and augment the position of the Nevis Island administration. Madam Speaker, the system-led Nevis Island administration is of the view that our responsibilities as outlined under Section 106(1) of the Constitution should not fall on the lap of the federal government. We are a government that does not shy away from our responsibility and one that believes in accountability. We therefore approve the addition of the Nevis Island administration to sue or be sued. Madam Speaker, I am pleased with the bill and I wish for continued growth between the Nevis Island administration and the federal government as we continue to work closely in finding legislative solutions to remedying issues such as these. Madam Speaker, with these few words, I bid this bill, the Nevis Island Administration Civil Proceedings Bill 2023, safe passage through this honorable House. May it please you.
Thank you to the Honorable Senator Jones. Is there another presenter? I recognize the honorable member for Nevis 9.
11.
Sorry, 11. I'm having a terrible time today with my numbers. I do apologize. I'm not very good at multitasking. Just a minute, Honorable. I was getting a signal from the sign language interpreters. Is it that there's a need to switch at this stage? Very well. You can do so before the next presenter. Ready to proceed? Very well. I recognize the honorable member for Nevis 11.
Thank you very much, Madam Speaker. Madam Speaker, I rise to make my brief intervention on the bill currently before this honorable House, the Nevis Island Administration Civil Proceeding Bill 2023, which is of course a bill to provide for the Nevis Island Administration to sue and be sued in its capacity as an organ of the Crown and for related matters. Madam Speaker, I rise to make my contribution, and I actually want to start by giving God thanks for the opportunity to be here, to make my contribution. And why I say that, we always have to give God thanks, but I'll put that into context as to why I give God thanks. This matter that we are now dealing with had its roots all the way back to 2017. And of course, the Attorney General was not the Attorney General then. And the Premier of Nevis, of course, was the Premier then. I was, at that time, the Minister of Lands and responsible for lands on the island of Nevis. And indeed, under the ordinance that governs acquisition of lands, indeed, I was the minister who would have brought this particular matter to the cabinet then. And even though at that time there were other issues relating to this particular case of this particular acquisition. As a matter of fact, I believe the matter was still live at the Privy Council at the point in time. And I say that because we made a decision then as the Nevis Island administration with the powers that were entrusted in us as an administration. We made a decision to proceed with the acquisition. The acquisition was done according to and consistent with the ordinance. And indeed, the Nevis Island administration is now the owners of those lands. But I say all that to say that I was there from the beginning. And I was there when the acquisition was done. I was there when the default judgment was ruled in favor of Ocean Reef then and against the Nevis Island administration. I was there when the senior counsel, Terence Byron, his name was mentioned before, and I give him commendation along with legal counsel from the Nevis legal department, Ms. Rhonda Nisbet Brown, who handled that case at that point in time. I was there when the matter was determined to be taken to the appeals court, that is, sorry. And I was there when the judgment was handed down by the appeals court. One that I believe all of us were surprised with, one that all of us had our difficulties with, and one that today we are here seeking to remedy an anomaly that occurred then. Of course, the judicial arm of government would have done what they had to do. Now the legislative body has to do what it has to do as well. And that's why we are here as legislators, Madam Speaker. We are here entrusted with that responsibility to correct any difficulties, any ills, or any circumstances that may arise that will create difficulties for this federation, whether it is from the Nevis end, as we're dealing with today, or from the federal end. At some point, I'm certain that we'll be back here to deal with other anomalies that the legislative body is being called upon to remedy. And so, born out of that judgment, we have had a lot of discussions, and indeed, discussions along the political lines, discussions along the constitutional lines. We have heard a lot of good points being expressed here this morning, and I embrace them all. And I must say also, Madam Speaker, that we live in a time when persons are now exposed to all sorts of platforms. And indeed, we live in a democratic society. People will say whatever they so desire. Who am I to stop them? Where you have the ability to rectify situations that may arise, we are asked to do so, and we are doing so. And so this morning we're here with this important bit of legislation that I am certain once we leave here with the 2/3 majority or support that we are seeking, we'll put an end to some of the doubts and some of the difficulties that that judgment rendered in August of 2022 would have created for the Nevis Island administration. I personally, from my standpoint, never had any difficulties in terms of where we stood as an administration. Because here's what I've said to my colleagues. The day after the judgment, we got up, we went to work. The premier was still the premier of the day. The ministers were still ministers doing what they were mandated to do. Civil servants came to work and perform their duties. The government continued to enter into certain transactions. So nothing changed as far as I'm concerned at that time. But to lay some or put some of the doubts aside, or put it to rest, so to speak, we have come today full circle to ensure that these debates will no longer persist, but rather the Nevis Island administration will continue to do what it has done for the last 40 years. and that is to govern the affairs of the island of Nevis in partnership, of course, with the federal government, as mandated by this document, the Constitution of the Federation of St. Kitts and Nevis. And so the debates will rage on in many ways, and persons would have different views and opinions as we go along. But as we evolve as a nation, we have to understand that these things will happen. But in our process of evolving as a nation, as a legislative body, we have to understand that we have to come here and we have to do what has to be done by us as legislators. There are other bills that I'm sure will be debated moving forward. And when we are out of this parliament, there are other difficulties that will arise. And I am hoping that the legislators of the day will do what is necessary to correct those difficulties. But Madam Speaker, the member for Nevis 9 would have asked for the support of the Parliament on this particular bill, and I see no reason why we should not get that support, because when it's all said and done, we're here to work as a harmonious body on both sides, because we will support the other side when time comes. It will come. And I'm sure the other side has no difficulty along with all of the other elected members on this side of the aisle. So I will prefer their support or urge them to support, and in so doing, let me wish this particular bill safe passage. I wasn't intending to be long because I believe that the legal side of it was already handled by the two learned lawyers who were presented before me. And who am I to question? Who am I to seek to repeat? Who am I to even bother to touch anything that they have touched, because they would have done so in an eloquent way. But I just felt that I had to lend my support in this fashion because I was there from the beginning. And I'm here still at this particular juncture when the Parliament is seeking to erase any doubts that may have come out of that particular judgment, born out of the action that, as Minister of Lands then, that I would have taken, not knowing that we would have come here today because of a judgment that would have created such difficulty and such consternation. But that being said, Madam President, I wish this bill once again safe passage and seek the support of all of the elected members of this Parliament as we seek to remedy a situation that we consider to be a difficult one, but one that can be rectified by all of us. I thank you.
Thank you to the Honourable Member for Nevis 11. I recognize the Honourable Member for St. Christopher 5.
Madam Speaker, I rise to make a brief contribution to the bill currently being debated, the Nevis Island Administration Civil Proceedings Bill. I have sat and I have listened keenly to the debate thus far, Madam Speaker, and I do understand that there's an issue and that the Parliament is being convened today, or has been convened today, in an attempt to bring a solution to this particular issue. I have heard the background with regards to the particular legal matter and the judgment coming from the court, which would have indicated that there is a lacuna in terms of the Constitution and perhaps what has been practiced. So the Parliament is here debating this particular piece of legislation, and as I said, I fully understand why. And I accept that there's an issue, there's a problem which needs a particular solution. However, Madam Speaker, I do have a point of departure. And that point of departure, Madam Speaker, has to do with the fact that this particular piece of legislation, if successful, as far as I am aware, would be the first piece of legislation debated by this Parliament and passed that changes two sections in particular of the Constitution of the Federation of St. Kitts and Nevis. A constitution which has been in effect since 1983, almost some 40 years now. Madam Speaker, it certainly isn't the first time that the court has issued a decision which indicates that we are in breach of the Constitution. We have the case which came out, I think, relative to the gentleman Sankofa to do with the usage of marijuana. And indeed, eventually, the Parliament was convened to settle that particular matter. Now, Madam Speaker, I suppose persons are wondering what exactly is my point of departure. I think it was sometime late last week, Madam Speaker, that I received notice of a meeting of Parliament to be convened this week. As a matter of fact, I received the papers, the bills to be debated. I think it could have been on Monday afternoon. Yesterday, I received an email indicating that there are some amendments to the particular piece of legislation. Madam Speaker, you have seen the order paper, and you would note that there are several bills listed on the order paper, with only 2 of those bills scheduled for a second reading today. And that is where I have that point of departure. Because we're speaking about the Constitution, Madam Speaker, and the Constitution fundamentally is the highest law of the land. It determines what we can do, what we cannot do. We have had various debates in this Parliament, and some of the debates have hinged on the very same matter of public consultation and giving persons the opportunity to be able to have an input in legislation. Here is a piece of legislation, Madam Speaker, which is going to change the Constitution, the way that St. Kitts and Nevis in particular conducts business, and unfortunately, the public, I'm not even going to speak about myself as a legislature and the amount of time that was given to myself or other members of the Parliament to really study the particular bill, but the public, Madam Speaker, is where I take exception. Consultation and allowing the public to have an input. It is not secret, Madam Speaker, that in terms of the relationship between St. Kitts and Nevis, and in particular between the NIA and the federal government, that we have had different issues over the years. Even before independence, Madam Speaker, we have had issues relative to the governance of the 2 islands. We can go back as far as our journey to independence in terms of that particular relationship and the antagonistic arguments, etc., that would have come out of that. We have seen, I think it was in the 90s, the exercising of Clause 113, which speaks to secession. And even in the administration that I was part of course, we heard the arguments relative to fair share, etc. And those became important arguments amongst the people of St. Kitts and Nevis. Let me make it abundantly clear, Madam Speaker, that I am not against what we are attempting to do. What I take exception with is how it is being done, with 3 readings in one particular day, without giving the public that opportunity to be able to scrutinize the legislation and to provide feedback in terms of the legislation. That in particular, Madam Speaker, is where I take exception. I heard the Honorable Premier for Nevis in his presentation, and he spoke to the fact that over the years, this has been the practice. And while, yes, it has been the practice over the years, it doesn't mean that we come to Parliament and in one sitting, we attempt to change the Constitution of the Federation of St. Kitts and Nevis. Madam Speaker, from 2004, I think, up until 2009, I sat in the Parliament, and there was no issue in terms of persons having dual citizenship, and I wasn't the only one who would have sat in the Parliament. But the Constitution said it differently.
On a point of order, just for clarity of debates.
I recognize the Honourable Member for St. Christopher.
Yes, on a point of order, he has stated that we are attempting to change the Constitution here. Nothing before this Honourable House is purporting to change a letter in the Constitution.
Madam Speaker, if you look at the legislation in terms of sections 102 and section 106 of the Constitution, they would be affected by this particular piece of legislation. As a matter of fact, it is why the Constitution says that you require a 2/3 support of the members of Parliament in order to make this particular change. So then why are we here? So, and Madam Speaker, I don't want to get into that, because then if it's under dispute, then more reason as to why we should not be here having 3 readings in this particular section if there's a dispute.
Just as to whether or not we need 2/3, that's what it's out of an abundance of caution. They're not changing the letter in the Constitution. Can you identify the amending section in the Constitution? Yes, I would like for the member to identify the section, clause, or anything in the Constitution that is being amended, just for clarity of this debate. Just identify it. Just for his own edification, it is out of an abundance of caution that I think the framers have put in that if you're doing something that like this, perhaps you should seek 2/3 majority. That is what the member, I think, from number 9 was trying to say, is that perhaps that is adding unnecessary confusion, because this bill actually, some may argue, does not require that, because it is not changing any aspect of the Constitution. And just for further clarity of the member, for number 5, and again, we're not debating here on the content of the bill, but just for his clarity, whereas under section 106(4) of the Constitution, it is provided that nothing in section 106(1) shall be construed as precluding the legislature from conferring other responsibilities on the administration. And so what the bill is doing is sticking with the Constitution allowing it to be pellucidly clear that the administration can be sued and not sued. It is not changing any text in the Constitution. So I just wanted to make that very clear to the general public that we are not here debating a constitutional amendment. So he has to be very careful with his words. So he needs to retract the statement that we are here to change the Constitution.
Madam Speaker, I think it has been made very clear that with reference to the ruling which came from the court has indicated that the Constitution does not give support to the Nevis Island administration being sued.
Speaker, I rise on a point of order. That is not what the court said, Madam Speaker. The court said that the Crown Proceedings Act does not give that right. So I think it has to be clear for the general public that there is no attempt by this bill to amend the Constitution. It is dealing with civil proceedings, something that can be done by legislation.
Madam Speaker.
Sorry, on a point of order.
No.
I want the...
Member for
Okay.
number 3, you have to allow
Yes,
Honourable
no problem.
Member for number 5 to respond.
For the retraction of the statement that this Honourable House is trying to amend the... And I just heard a very loud stoops coming from the audience. I would like you to alert the audience that that is out of order in this Parliament.
Before you respond, Honourable Member for number 5, members in the gallery, I wish to remind you that this is a place of order. I am not certain who it was, but kindly refrain from that type of behavior. It is disrespectful to the members. They are here representing various constituencies, and they have the right to debate in the manner that they are debating. Any further interruptions of similar kind, I will ask for the officers to remove you. Well, you may proceed, Honourable.
Thank you, Madam Speaker. Madam Speaker, my main point has been that you have no opportunity has been provided for consultation from the public. As I said, Madam Speaker, you have several bills listed on the order paper. And it is interesting.
Madam Speaker, the statement that we are debating an amendment to the Constitution is grossly inaccurate and false. That statement needs to be retracted for the record. That is not what we are here to do, and we ask the member for number 5 to retract that statement.
Yes, Honourable Member, but he hasn't even finished his sentence. Allow him to finish, and then we'll make a decision.
Madam Speaker, I have no issue if the Honourable Member wants that statement to be retracted. I have absolutely no issue with that, because the main contention that I have, it still stands, is that there has been no consultation with the public on this particular piece of legislation. A piece of legislation that is a fundamental to how we govern our affairs, in particular between the two islands. As I've pointed out, Madam Speaker, over the years, we have had much debate in terms of how we go about our relationship between St. Kitts and Nevis. And I find it interesting that we're here having 3 readings of this particular piece of legislation. And so you wonder what makes this particular piece of legislation so urgent as compared to the other bills which only had a first reading. Madam Speaker, it has come out during the debate that the ruling from the court is one which was issued sometime during the course of last year. And so that says to me, Madam Speaker, that for quite some time now, we have been aware of that particular ruling coming from the court. So it means that there has been more than sufficient time, Madam Speaker, to allow the public to have had sight of this particular piece of legislation and to provide input on the legislation. Madam Speaker, we have had numerous issues which have come before this Parliament, and we have heard the same argument, that one ought to allow the public to be able to participate in the debate, to give their feedback, to give their input. I have not heard throughout the debate why this has become urgent as to allow it to have 3 readings today. There's a particular piece of legislation that I note is also on the order paper, and based on certain statements that we have heard being made public, I am almost certain that before the end of June, we will be back in this Parliament to debate that particular piece of legislation. And so one wonders, just as that is likely to be the case, then what is the harm of perhaps bringing back this piece of legislation at the same point in time, if indeed we are here before the end of June? And so, Madam Speaker, that is my point of departure relative to this particular piece of legislation. May it please you.
Thank you to the honourable member for St. Christopher 5. Do we have another presenter? I recognize the honourable member for St. Christopher 7.
Thank you, Madam Speaker. With your leave, I rise to make a brief contribution on the bill. And perhaps I should start where the member for number 5 ended. Because I recall some time ago, I raised in this honourable Parliament and asked the Honourable Attorney General whether the long-established tradition of putting bills, bringing them, having the first reading, allowing them to go out to the public for input, whether that was going to be continued. Because when we started, there were a number of bills that were coming for 3 reading. The Attorney General said, listen, those bills that we were bringing for 3 reading and 1 sitting, basically, our bills were straightforward. For example, the bill we debated in relation to the church. There was no dispute in relation to this matter. However, he did say that his view was that sending out the bills to, for example, entity like the Bar Association was an important part of the good governance agenda and allow the debate and the legislative process to be enriched by that. This bill, which we are dealing with today, is no simple bill. How can it be a simple bill? This was a matter adjudicated by the courts, 2 courts, the High Court and the Court of Appeal. A matter dealt with, Madam Speaker, by 3 justices of the High Court. Who they were, Madam Speaker, for the record. The matter that has brought us here, according to the Attorney General and the member for number 9, the Nevis Island Administration appellant and the Ocean Reef Resorts Limited respondent. The matter being heard before the Honourable Dame Janice M. Pereira, DBE, Chief Justice, the Honourable Mario Michel, Justice of Appeal, and the Honourable Mr. Girard, Saint C. Ferrara, Justice of Appeal, acting. What does the head note say to us? It is an interlocutory appeal, preliminary issue, the juridical status of the Nevis Island Administration, whether the Nevis Island Administration is part and parcel of the Crown for the purposes of civil proceedings pursuant to the Crown Proceedings Act, whether the Nevis Island Administration was the proper party to be served with the claim, request, and entry of the default judgment. Critically important issue in a simple matter, and the fact that in relation to the judgment, the three justices all were of the same view with the ruling. This wasn't just one judge ruling. This was three judges, written by the Chief Justice, perhaps the most eminent of judicial personalities in the region, the longest serving member of the OECS Appellate Court, and concurred. I concur, said Mario Michel, Justice of Appeal. I concur, said Gerard Saint C. Ferrara, Justice of the Appeal, acting. No simple matter. We have heard that this is new, that there was a customary approach to it, that Nevis Island Administration had certain powers given by the Constitution. But those very arguments were canvassed before the Court of Appeal, put before three learned justices, and each of them denied those arguments. That is what has brought us here. Surprised, yes, we all were surprised. But because we are surprised of something doesn't deny the reality or the correctness of it. And when I listened to the presentation by the learned mover of the bill, I asked myself, and the member for number 9 raised it, one option, really, if you feel so strongly about the matter, go to the Privy Council. Go to the Privy Council and have it determined, because you had that right. Somewhat, maybe 9 months have passed. Remember, for number 9 was right. Ample time for the matter to be discussed, for the government to have had, given that it was 3 justices on the appeal benches that were concurring with the judgment, to make a determination. Do we need additional advice from that which we had from within on the matter? Should we engage a constitutional scholar to come in and to help us understand the full ramifications of the judgment of the Court of Appeal? That is a significant matter. And, Madam Speaker, this, of course, is anchored in the constitutionality. The powers that are laid out for the NIA in Chapter 10 of the Constitution, fundamental to the functioning of the NIA. We all agree with that. So when the member number 5 spoke about the Constitution, it was a relevant argument. Look at the bill. The bill, we came, you got this Monday, yesterday, a new version sent out. But look at the bill. Let's read. A bill to provide for the Nevis Island Administration to sue and be sued in its capacity as an organ of the Crown and for related matters. And then, whereas under Section 102 of the Constitution, there is an Nevis Island Administration, and whereas under Section 106 of the Constitution, the Nevis Island Administration have exclusive responsibility for administration within the island of Nevis, and they list the various areas specified in the Constitution. The court canvassed all of these arguments The court look at this very section, and that is why they are here. How many bills would come to Parliament almost in the format of a resolution? Whereas, and whereas, and whereas. And then section 106, subsection 4 of the Constitution, it is provided that section 106 shall be construed as precluding the legislature from conferring other, that nothing in section 106 shall be construed as precluding the legislature from conferring other responsibilities on the administration, and whereas under section 37, subsection 6 of the Constitution, it is provided that the Parliament will make additions. Well, this section has been changed to matters specified, etc., etc. Reference to the Constitution. At the heart of the matter, are powers expressly put in the Constitution, and which the court has made a determination on. This is fundamental. This is not just a matter, respectfully, for the chambers of the Attorney General and the legal department of the NIA. This is a matter so fundamental. And I feel what the member for number 9 and 11 express in terms of the implication of it. But the entire country should have an opportunity to at least know more and understand the ramifications of the bill that we are bringing here. The entire country. There goes the fundamental point of the consultation. If there was ever a bill that required it, it must be this one. Because this is a matter that went before 3 judges. I listened, and I hear the arguments eloquently put by the member for number 9 about this case, the choice case. And when I scan, I said, but why are we hearing that? Because the 3 judges looked at the choice case. That matter went before them, and they determined that it was wrong. Let me see if I could find the section. It is important. This matter, in my view, is not yet ready. And I support the position of the member regarding why do we need to rush it through. Fundamentally, we wouldn't argue about the NIA having the authority, but we need to get an understanding of the context, what it means, where would it lead us, and whether the remedy we are bringing suffices in relation to what the justices have claimed in relation to the matter. Importantly, Madam Speaker, because we again had this argument, this interruption of the honourable member in relation to the issue about constitution. But here what 3 justices of the appeal court are saying, a useful starting point for determining the juridical status of the NIA is to consider the relevant provisions of Chapter 10 of the Constitution, which sets out specific provisions in relation to the island of Nevis. It is a constitutional matter. The Chief Justice and her 2 eminent colleagues are saying to us that the useful starting point for determining the status of the NIA is to consider the relevant provisions of Chapter 10 of the Constitution, which sets out the specific provisions in relation to the island of Nevis. And that is why in the bill itself, it's almost like a resolution. Whereas, and whereas, and whereas, and whereas, and every whereas fundamental to it is a constitutional provision. Because that's what people who determine the law in an objective and impartial way. They are not like lawyers with a side to take. They are independent. That is why they are separate estate in the governance of the country, independent arm of government. That is what the judiciary is. And it goes on again to spell out all these exclusive powers. So the very arguments I'm hearing canvass in support of the approach we are taking, those arguments have already been canvassed before the appeal court, and they have found no favor. And so I am concerned, even if the approach that we are taking now would satisfy the requirements of the Constitution, because the arguments were there. It was for the court to make determination. The powers, the Chief Justice took note of it. It is clear from the provisions, I'm reading from the judgment, Madam Speaker, it is clear from the provisions that the Constitution confers on the NIA substantial authority as an organ of government for the island of Nevis. The court never disputed that. The court itself says that. But when the court looked at the available evidence, the constitutional frame, the court said no, it could not be done. And that is the reality which we must live. And the fact that the government, the NIA, did not choose to go one of the route that was available to them, to the Privy Council for final determination, whether the court had gone out of bounds, whether the court had done some misapplication in its ruling, tells me that they themselves had become to accept the judgment of the court and therefore sought to bring this particular approach.
Madam Speaker, it is unusual for members of the opposition to get up.
Are you rising on a point of order?
I'm rising because I'm hearing the honourable member for number 7 purport to speak for the Nevis Island administration.
It's on.
And I'm just, the suggestion that we accepted this decision, and therefore that is why we're here. He has no authority and no basis to make that conclusion on behalf of the NIA. As I made it clear, there has been ongoing consultations between the Office of the Attorney General and the legal department. And that we chose one of the options available to us does not mean that we accepted the decision. And I think I made that very clear in my own submissions, that we thought that the judge erred in relation to this particular matter. Our system allows us various routes to correct that, and that is why we're here, having chosen this route. So I would ask the honourable member to confine his observations to what he knows and his opinions. That is okay, but not to speak for the NIA, of which he's not a member.
Thank you, member for number 9. But to be clear, I was saying that was what I deduced. I am entitled to a deduction. I'm not saying, I'm saying you identified 2 routes. And I'm saying it must beg the question why one route is taken instead of the other. And I'm making a deduction that is reasonable, that flows from it. And that is why it would have been important if we had fuller discussion, if there were consultation, more things would have been aired. We were advised that there were to be a meeting of both parties on a fundamental matter, and I'm going back again to the judgment. Going back to the judgment, because this is what has brought us here today, and we want to be helpful. I am not raising this to get in any argumentative approach. I am raising it because it is fundamental. It's member, Honourable Speaker, could I be allowed?
Remember to make his presentation, please.
I'm not contradicting myself. Please allow me. No, I'm not easily distracted at all. Anyone who knows me know I'm not easily distracted. But it's
Honorable
improper.
members,
It is
please
improper what
allow
you're doing.
the honorable member for number 7 to make his presentation. Everyone is given the opportunity to speak. Some have taken, some haven't. Please await your turn. Proceed, honorable
Thank you,
member.
Madam Speaker. I read again from the judgment, a section of it, after enumerating the 8 specific areas for which the NIA shall have exclusive responsibility. So this again went before the High Court, went before them. Every issue marshaled today in support of this matter went before, and that is why he begs the question. It went before the justices, the Chief Justice, who, as a member for number 5 said, well, this was not even an issue that was canvassed by the litigants, but the Chief Justice, in her wisdom, considered that at the gravamen of the issue at hand, the fulcrum of the matter to contend with were matters of constitutional importance. And this judgment is replete with reference to this. And this bill comes replete with reference to the Constitution. She says, and it was concurred with by the other justices, Section 106 of the Constitution carves out 8 specific areas for which the NIA shall have exclusive responsibility. So she understood that. She knows it. She's a practicing lawyer, one of the most respected ones. I note, this is important now, I note that there is, however, nothing. This was Chief Justice speaking, and I am repeating. She says, I note that there is, however, nothing in Section 106 which imbues the NIA with legal standing to sue or be sued in respect of land. Member for number 11 raised the land matter, and buildings vested in the crown, or indeed in respect of any of the other areas of exclusive responsibility. Having considered the relevant provisions of the Constitution, this was what guided the judgment, it seems to me, and that is the Chief Justice speaking, that the NIA, barring public law or Crown-side type proceedings, has legal standing only. It wasn't that this matter was canvassed. It wasn't that the court, but the court defined in its wisdom, not challenged before an appeal court, has only in circumstances where Section 1112 is engaged. And she goes on in the subsequent section to say what 1112 is concerned with, disputes between NIA and the federal government, and so on. The member for number 5 then was going an appropriate part in terms of reference to the constitutional importance of this and what we're attempting to do. Because here the learned Chief Justice is saying clearly there is nothing that allows it to happen in the Constitution. 106, she says, doesn't. I note, however, nothing in Section 106 imbues the NIA with legal standing to sue or be sued. Goes on. Another section important to discussion. What is more critical to the issue of the NIA's legal standing is the provision of Section 3 of Schedule 5 of the Constitution. What is the point being reinforced? It is a constitutional matter. It is a constitutional matter in the main. That's the government of the problem. And that is what the Chief Justice was going. She says, according to that section, the Nevis Island legislature has no power to make laws relating to proceedings by or against the Crown, other than as it relates to the conduct of proceedings under Section 112. The upshot of this is that the Nevis Island legislature has no power to enact legislation which disapplies the provision of the Crown Proceedings Act. The upshot of the learned Chief Justice, Dame Janice Pereira's interpretation of our Constitution was that the Nevis Island legislature has no power to enact legislation which disapplies the provision of the Crown Proceedings Act. And a fundamental part, as you go to the judgment, is the indivisibility of the Crown. The state, as the Attorney General says. Critically important. This, in my view, is tacit recognition that in relation to private law proceedings brought in Nevis by or against the Crown, the Federal Parliament intended the Crown Proceedings Act to apply, and it is perhaps useful now to consider proceedings which are relevant to the preliminary issue. And it goes on to look at the Act and all of those things, which I won't go through, but it's an important reading as we address issues and we move importantly to broader issues of constitutional reform, how we are going to address them. She goes on to say, well, Ocean Reef claim constitutes civil proceedings for the purposes of the Crown Proceeding Act. It is undisputed that the Act is federal legislation which applies equally to both St. Christopher and Nevis. And so on, and she gave other. This was made plain in Brian James versus the Attorney General, a St. Lucia case, which considered the equivalent provisions of the St. Lucian Crown Proceedings Act. There are no provisions. There are no provisions in the Constitution which disapplies Section 3 or indeed any other section of the Crown Proceedings Act in relation to Nevis. The founding fathers, we are told, knew of the existence of this act from about 1956. Would have gone to it again in 1977, we are told. 1983, they saw no need to change it. No need to change it. That is a reasonable conclusion. There are no provisions in the Constitution which disapplies Section 3, indeed any other section of the Crown Proceeding Act in relation to Nevis. And we've brought two pieces of legislation to attempt to do that. We have brought two pieces, this and the Crown Proceedings Act. But is it enough? Is it really dealing fundamentally with the government of the problem? So elusively put out in the ruling of the High Court. Not the High Court, the Appeal Court. Appeal Court. 3 judges. Goes on to say, there are no provisions in the Constitution which disapplies Section 3 or indeed any other section of the Crown Proceedings Act in relation to Nevis. There is also no separate Attorney General for Nevis, we know that, but one Attorney General who serves as the principal legal advisor of the Federation. Furthermore, no specific carve-out has been made to permit the NIA to stand in the shoes of the Attorney General as it relates to civil proceedings commenced in Nevis against the Crown. It would therefore not be correct, in the view of the Chief Justice, to simply infer that NIA has legal standing to be sued in such proceedings in the absence of a clear intention of the Federal Parliament for Section 3, etc., to be disapplied in relation to Nevis. And she goes on, she considers it necessary to underscore that the issue of the legal standing is being considered within the context of proceedings which are civil in nature, which are distinct from judicial review or public law proceedings. And she goes on to say, what is the settled law? Importantly, we, the government, put forward the case in support of continuing what was the practice. This was how it was being done all the time. We heard that. And that is in part why the surprise came to all of us. And so, of course, one empathized with the situation, difficult as it is. We had the Solicitor General, Simone Bullen Thompson, her written submissions, while accepting that the NIA is a component or emanation of the Crown, contended that the court should nonetheless construe the provisions of the Crown Proceedings Act to allow the institution, etc., of civil proceedings by the NIA. And she goes on to talk about the autonomy issue, previously canvassed and dealt with explicitly by the court and so on. And she raised the case raised by the member for number 9 of the Choice FM Limited versus the NIA issue and the observations of the court. And she addressed that. And in fact, in that very case, to me, interestingly, the High Court judge then recognized also a particular, well, I shouldn't say troubling, but recognized an alternative view to the one he was taking could apply. Because he said, if it is accepted that the NIA is a component of the Crown, then the Crown Proceeding Act applies, and the proper defendant to cite is the AG. If the NIA is not the Crown, or a component of the Crown, which Simone Bullen accepted, it's an emanation of the Crown, then it must of necessity be regarded as a private entity. Specifically, I am unable, says the learned Chief Justice, to agree with the submissions of the learned Solicitor General on this point. And having considered Choice FM Limited decision, I do not agree with the reasoning of the court for two main reasons. Two main reasons. I ain't a lawyer, but I understand some of these being a legislator. The court above make a decision, binding on the one below in the said jurisdiction. So here a court below made a ruling, perhaps never appealed, and she's saying clearly, I do not agree with the reasoning of the court, and she gave two reasons why it could not follow in this particular case. Firstly, the mere fact that the civil proceedings by and against the NIA alone are commonplace. We heard that argument mushrooming today. It's commonplace. It was the norm. It's been going on for over 40 years. And that is why I said, well, I have a discomfort. Because you can't be persuaded if the very arguments you are using, canvassing, had already went to the relevant body for consideration. And the relevant body made a determination. She said the mere fact that civil proceedings by and against the NIA alone are commonplace is not a good or legitimate reason for disregarding the clear provisions of the Act. As the Judicial Committee of the Privy Council expressed, she gone higher than herself now, the final court in our jurisdiction, the Privy Council. She says, as the Judicial Committee of the Privy Council expressed in Beverly Levy versus Kenkanes and Marketing, as this court observed in Ferdinand James versus the Caribbean Practice Limited, a common practice engaging over a number of years, and this is the argument, over 40 years, does not thereby render it correct by common and repetitive usage over time. These are strong, clear judgment, pronunciations on the matters. Courts are required to interpret and apply the law, and not disregard it because of what it may be perceived as leading to some practical inconvenience. It certainly does not lead to an absurd result. To the contrary, it goes a long way towards ensuring certainty and removing the recurring doubts which have historically attended matters of this kind. And she said, those are demonstrated by the choice of a limited decision, unlike cases. For these reasons, said the Chief Justice, and concurred by 2 other justices on the appeal court, I do not regard the choice FM decision as instructive on the issue of the NIA's legal standing. Madam Speaker, you see what the court have determined. And you see why the member for number 5 was talking about constitution and all these things. You see why there is a need, the public out there, for us rather than come today without more, to have 3 readings of such an important bill, so that we could have some clarity. We don't know, for example, of the views of the Bar Association and important stakeholders was had in this very important matter. We don't know. We don't know what is the views of other legal luminaries outside of the government system. We don't know. So we can't be sure that this approach basically that is coming, how this is going to solve the problem. And she goes on, and we heard about Africa and all other things, but she went on to look at other jurisdictions in our Commonwealth. And they have 2 islands, if you will, and what the law provides and how it operates. And so, Madam Speaker, the issue of this need at the last moment to come and to push this bill through without consultation is a matter of serious and significant concern. Because we have heard already of the serious ramifications for Nevis, the cloud of uncertainty, and all these other issues that have been raised. And these are, of course, matters which, of course, we consider and we feel for. But the question remains, are we proceeding in the right way? And are we, as it were, attempting to bypass, walk around the objections of the Chief Justice? And can this be done by mere legislation alone? That is an important issue, Madam Speaker, which we have to contend with, and we need some clarity. I think that this bill would have benefited from wider circulation. This bill would have benefited from further advice coming outside the circle in which the advice has been sought, that we know publicly of. And this bill, when it comes, would have certainly been in a better position to receive widespread support. Madam Speaker, I am comfortable with the haste, that is the three reading in one sitting of something that so fundamentally is replete with constitutional implications. Madam Speaker, constitutional implications of a far-reaching nature that can have destabilizing impact upon our country. And that is why, Madam Speaker, I would ask that this matter be reconsidered in terms of the approach. We have not yet gone through the committee stage. There's still time for us to have the benefit of further advice on the matter, so that one has clarity really as to what it is we are attempting to do, having regard to the ruling of the Chief Justice, which found support of 3 other justices on the appeal benches of the court to which we subscribe. I concur, said Mario Michel, Justice of Appeal. I concur, said Gerard Ferrara, Justice of Appeal, acting. Madam Speaker, this is a serious matter requiring serious consultation and discussion. Nothing that has been said here have not, in my view, been already discussed in this judgment, and a particular finding the court arrived at. And so I am not satisfied that this bill really will resolve the problem so fundamentally at bay at this particular moment in time. Thank you, Madam Speaker.
Thank you to the Honourable Member for St. Christopher 7. I recognize the Honourable Member for St. Christopher 3.
Maybe. Madam Speaker, with your leave, I rise to make an intervention, as it was not originally my intent to speak on the bill before this Honourable House. From the outset, I would want to state that there is no objection to always having all necessary level of consultation that is required to ensure that the decisions taken by this Honourable House fall within the comfortable acceptance of the general public. But consultation, or the argument of consultation, should never be used as a tool also for political grandstanding. Of course, there are many different forms of consultation, many different forms of making sure that every effort is made to make the right decision. But just because you could wave the word of consultation in the air, which was very lacking, I must add, over the last, before August of last year, for 7 years, it's not sufficient just to wave this argument of consultation and cloud it with quotes out of context from judgments without actually getting to anything substantial. In fact, you know, we looked at, and I know there is still discussions, as I said, we have no aversion to ensuring that a bill is fully ventilated. But I want to make, well, before I make this point, I want to make sure the point is very clear about, just mute this computer. Make the point very clear about not using consultation as a tool. And it is amazing to me what some people will do just for the purpose of relevance or trying to be relevant. One point I would want to make about that consultation issue is that the member from number 7 said that there were 2 options provided. You could have appealed the decision of the Court of Appeal. Let's look through that for one moment. If you appeal the Court of Appeal decision and it went to the Privy Council, and the Privy Council, let's say, agreed with the NIA's and everybody else's position that there ought to be no additional law or anything such that the NIA can sue, there will be no consultation. You understand? If you went to the Privy Council, we wouldn't have this. The public wouldn't become any wiser because the status quo would have then continued. So this idea that is being purported, that this particular thing, which has been established for 40 years, is in dire need of further consultation, I need to see more of what you're referring to. Bringing me to my next point, that in this House, there is a tool that allows for this Parliament to decide that if a bill has no general objections, whether in the Parliament or in the public, that it can be read for a 3rd time. Although that was not necessarily going to be the case here, because the option existed that we could start the debate, allow for some further ventilation, and come back and finish the debate at another time. That still exists and was always on the table. But when you come to make that decision, you're going to ask yourself, what are the salient points that have been raised that will allow or substantiate the need to delay the decision? So for instance, if this bill was saying X, and the opposition is saying, well, it should not say X, it should do this or it should do that, making it controversial, then perhaps you need some revision to that. But the opposition offered no amendment, no suggestion, no difference of anything within the bill. The members who opposed, sorry. The members who opposed on the opposition. So the opposition is opposing the opposition, right? Right now. Has that ever happened in this Parliament? The opposition opposing the opposition. They have not provided. The member for number 7, we all know, and I guess when you're on different sides of the aisle, it allows for persons to see that a lot of the flowery speech in the past was also not predicated on substance, but predicated on a grandiose style to suggest that you know what you're talking about. But he stood and spoke and offered not one contrary position to what the bill is purporting to do. Nothing. So therefore, like when...
Point of order. I offered...
Let him speak. I recognize the honourable member for St. Christopher 7.
Yes, Madam Speaker. I put forward the concerns, which is my right to do. And I looked to the legislation, the judgment, to say that every point that was being put from the other side already being adjudicated on. That is the court to determine that they will not go any further.
This is a point of clarification or a point of order?
Point of clarity, point of order.
You have a right
Madam
to rise
Speaker.
on a point of order, not a point of
You rule on
clarification.
it, Madam Speaker.
I am ruling now. It is a point for clarification, not for order. You raised issues, you opened a particular door, and so responding members, as I usually allow, have the right to respond to what is being put on the floor. Proceed, Honorable Member.
Thank you, Madam Speaker. So I want to make the point absolutely clear. The member from number 7 also referenced a bill that was passed in 3 readings for a church. Now, the reason why that was able to be passed in 3 settings is because nobody in this house could offer an alternative perspective to that church getting what it needs to get. So therefore, if it is, and I think there's also a further contradiction, because the member from number 5 in his...
Honorable Member for number 7, whenever you're speaking and someone interrupts you, I stop them. I give you the right to present. You presented for a number of minutes. Allow the Honorable Member on his feet to do the very same. I afford you protections, and so I must afford the others the same protection. Please stop interrupting the member for number 3. Thank you.
Thank you, Madam Speaker. Although I was not distracted. I kept going, unlike others. I was not easily distracted. Others were. But, Madam Speaker, the member for number 5, even in his opposition, said he has no opposition to the content of the bill. And so therefore, it is just pulling this argument of consultation out of the sky, it seems to be relevant, when they have not identified what it is needs consultation on. Because they could say, well, the way in which it has been structured, somebody might say it needs to be somewhere else. Also, what is being proffered here? Or let me go further in saying that all that was mentioned by the member from number 5 and the member from number 7, I have a note here. There was no objection to any of the content. So in effect, there is no controversial aspect of the bill and what it is purporting to do. In fact, the court has said, in their opinion, that there is a particular lacuna because it is not specifically specified. So for instance, if we can think of something outrageous, like let's say the Constitution, I think, references that you can't take the life of somebody else, but it uses some language like you can't do something with life.
You could say the Constitution doesn't say you can have a government with 3 elected members, but they do it still.
You could say that, huh? I might come to that too. But the Constitution can say you need to preserve life or something. And we would think that we didn't have to write a law that says do not kill in order to preserve life. But somebody goes and says before the court that, well, the Constitution didn't tell me not to kill. And so the court says, and as usual, makes the point, walks out, doesn't participate in the discussion, is not interested in the debate, member for number 7, as is the case always, making the political point so that he could get the snippet, get it on his favorite social media platforms in order to get his particular message out. And so the Constitution might say you need to preserve life or something, and somebody brings a case and says, well, it did not say specifically not to kill. And so the Constitution, some judge somewhere says, well, you're right, it doesn't actually say that, etc. So we have to look at this and you have to look at that. You could take a decision, appeal there and go to the Privy Council, or you could go back and if the Constitution allows you, say, look, you could do some amendments to things and so on. You can go back and write, do not kill. The discussion, the debates have already happened. The courts have already opined on this. And they have said in their judgment that something is missing. All this House is doing is coming to write that little something that the court say is missing so that there is no doubt. No, I don't know the legal term for it. There's a fancy thing to say out of abundance of caution. What is it? Y'all remember it? Because it's what is it, Latin? I can't remember these Latin terms. But all we're doing here is saying that after all that has happened, all the things happening in the court, the back and forth between the legal people, the Attorney General's office, the Nevis Island Administration legal advisor, saying, you know what, let's just write it down so it's absolutely clear. And use the Constitution, the powers given to this Parliament by the Constitution to make that correction. And so, one very important thing is to say we are not amending the Constitution. I want to make that absolutely clear. The member from number 5 was mistaken in his comment, and if I hadn't made that objection, I am pretty sure the member from number 7 was going to get up and try to say the same thing. But we are not amending the Constitution. What we're doing is using the powers given to us in the Constitution to make a simple thing, not guesswork, but putting it in writing so that it is very clear. So it says on the bill, whereas under section 106(4) of the Constitution, it is provided that nothing in section 106(1) shall be construed as precluding the legislature from conferring other responsibilities on the administration. I think it was the member from number 9 who had said, based on the fact that you were given full responsibilities, we did not think, or no one thought, that you have to specify that somebody can be sued and not sued. And so what this part of the Constitution allows us to do without having to amend the Constitution is to say, you know what, just so that we are clear, when you have a responsibility given to you in this regard, you can be sued and not sued. The Constitution gives us the ability to do that. And I also want to refer very quickly as well to a piece of the legislation, sorry, not legislation, the judgment that the member from number 7 was referring to. Let's see if I highlighted it. Yes. It is therefore clear, it says, that, comma, barring public law. So the judgment is saying, unless there is some law that establishes your ability to sue or not sue, then this is what our interpretation is. So we have then taken the option to use a law to make it absolutely clear. What would have been useful for the debate from the two members opposite who are opposing the opposition is to come and tell us if there was something wrong with what the bill is trying to do. And nobody is opposing that. Are they saying that when it goes to the bar, and for instance, are they saying when it goes to consultation, that people are going to come back and tell us that the court is wrong? That we shouldn't give the NIA the power to sue or be sued? Are we saying that there is a feeling that people in St. Kitts and Nevis are going to kick up a storm when we learn that somebody who makes a decision for $100 million can be sued or to sue? Is that the concern? Is something we're doing here going to cause people to think, boy, that's a controversial thing, boy. No, no. The NIA must be able to go into a contract for the airport, decide that they're going to spend $10 million, and if something goes wrong, that's not the responsibility of the NIA. That is what we are concerned of. Will nobody offer those arguments? And so that is why the Constitution and our rules give us the tool to be responsible legislators to say, if something is uncontroversial, if something is clear as day and night, if something is a no-brainer, if something has been properly ventilated by different arms of our government over a period of time, then you don't have to waste any more time and just pass the change. That is what the tool allows us to do. In fact, we have that power to do so. I would not have minded if they came and said, look, there are elements in the society who think that the Nevis Island administration should not be sued or that it cannot sue. But they have not offered that. What is before is uncontroversial. I can't use the fancy legal terms I remember from number 9 because, as he said some time ago, I'm only a lawyer by osmosis. I can't use those terms. But it is clear as day for us that nothing in this is controversial. I don't know what the term is when you have 40 years of doing something and then you realize because of some intervention that there is a word missing somewhere and you go and correct that word. You don't need another 40 years to just do it and get it over with. And so I want to say that we are not opposed at all to engaging in further consultation, and perhaps we could even have a discussion about that. But it can't just be for the sake of saying consultation. It must be because you have identified, and we agree, that there is something that is missing, and perhaps we need to seek further clarity on this issue. And so I found, especially the presentation from the member from number 7, to be particularly disingenuous because it used references to the court proceedings out of context in some instances, purported to speak on behalf of the NIA in a presentation that at the end of the day left us none the wiser as to why we must delay or not delay. Because there were considerations as to whether or not, as always, is this bill a controversial bill? Will it get opposing views from anyone opposite to the moving side of this bill? Or even within a particular side? Because as we saw, I don't know if the opposition or the majority of the opposition thought they would get opposition for this bill. Because if they thought they would get opposition for this bill, perhaps they would say, well, let's put it off a little longer. But we could not have thought that to make a statement in law that the Nevis Island administration can sue and can't sue would be up for controversy. Because that is, I think, a very basic principle of law. That if you are responsible for something, you are responsible not to do the things, but for your actions as well. And so that is why nobody thought that it had to be explicitly said. And all the legislation here is doing is making it explicit that, one, we're not amending the Constitution, but we're saying in order to adjust the Crown Proceedings Act that came into force before the Constitution that we need to make some basic changes to bring everything in line. I think the Honorable AG made a very, very valid point that the Crown Proceedings Act is older than the Constitution. And it is quite possible that in framing the Constitution, there were some things that were missed. And it happens all the time in the development of law. You know, I always joke with the lawyers and so on, you know, in my field, engineering, very precise. The numbers haven't changed for 100 years. 2 + 2 has always been 4 for a long time. But in law, a law is written today, and tomorrow there's something found that it might be contradicting some other law that was passed 100 years ago, and so you have to come back and just make the adjustment. But the final point is not in contention today. And if there were arguments made that said that the final point of whether the NIA can sue or be sued was in contention, then we could accept the arguments. The other thing, too, to note is that even the way in which we have done it, in terms of using a new bill called the Nevis Island Administration Civil Proceedings Bill 1, or amending the Crown Proceedings Bill Act, even those were not under contention in terms of how we did it. The only thing is that they want, for instance, just to make a point, that we should have broader consultation. But they didn't say why. When you have broader consultation, it has to be that something is amiss. You believe that if you go this way, that's not going to be accepted by part of the community or the society, or you're going to be breaching the Constitution. So I want to make it clear as I wrap up that, one, we are not amending the Constitution. I think that was an unfortunate statement by the member from number 5, because yes, as we seek for broader constitutional reform, the entire country, communities, all stakeholders will be involved in that process. So we're not seeking to amend the Constitution. What we are seeking to do is to use that Constitution. And I believe in the judgment as well, Honorable AG. The learned judges, or the learned court, said that they did not believe, it seems, the federal parliament was of the mind to let Nevis Island administration be sued or to sue. The federal parliament. As of 1956. So now the federal parliament has come to clarify its position. Not to change the Constitution, but to clarify its position that yes, in fact, since it was not clear, as the Constitution has given the Nevis Island administration these particular powers, the federal parliament, in agreement with the Nevis Island administration, states that we all intended and have practiced for the 40 years gone for the Nevis Island administration to sue and to be sued. So there is no requirement of the judgment even to have constitutional reform on that issue. The issue is, how can we use law to close that particular lacuna in the Crown Proceedings Act? And so we are here today to use the Constitution that allows us to say, you know what? In fact, the Constitution allows us to say we'll give Nevis additional responsibilities. But we're not even trying to do that here. We're just trying to make it absolutely clear to everyone that if you do something against the Nevis Island administration, that they can sue you. Because they have responsibilities for what they have responsibilities for. And if the Nevis Island administration does something to you, you can sue them. That's all we're trying to do here. And if it is that there were objections to that their constituents expressed to them, it would have been worthwhile to bring those objections here as to why we should not continue the debate. Because if they said, look, my constituents are saying that there is a better way that we can do this, then we listen. If they say that instead of doing a bill called the Nevis Island Administration Civil Proceedings Bill, instead of this it could have been something else, we would listen. But they didn't offer any of that. They didn't offer any objection. They didn't offer any content improvement. They didn't offer anything other than to say, we shouldn't do this simple thing in a sitting of Parliament after it has been exhausted by all arms of our government. First, of course, the court, and we're now doing it, and then the executive, because the executive consulted to determine what they will do based on what the court has said, and now we're coming to the Parliament to make a simple adjustment where none of them who have gone before have identified an alternative position that is available. And so I really want to, I was saying that one, we're not here to amend the Constitution in any form or fashion. And two, we're just here to make it clear, since it wasn't before, although everybody, all the legal, what was interesting from this, that member from number 9 said, is that the legal fraternity who was involved in this case, the legal fraternity said they understood this to mean that the NIA can be sued and that the NIA can sue. So even in that fraternity, there's no objection. And so the Parliament was just being efficient in doing all that, the work that it has to do. Come here and say, you know what, let's make this simple change. But the reality is, if members had found credible things that needed further discussion, because they didn't offer any. If we pause now to consult, we don't even know what we're going to consult on, because they haven't offered an alternative view. And so I want to support the bill before this Honorable House, the Nevis Island Administration Civil Proceedings Bill. It is uncontroversial. There's no contention here. If it were, I would certainly want to support that we make sure we take it out and go to, Gingerland Primary School, wherever we have to go. But I don't think that is needed here. I don't think it is needed. There are a lot of other critical matters that require further ventilation. Let us not use consultation as just a political tool to do your grandstanding. Stand, get your pictures, your video, your snippets, your shots. Honorable member, that is part. Honorable Speaker, please. I think that is part. That is, we have to understand. Yes, I think so. I think it is important to observe that, and for the public, because I want to stress this, Madam Speaker, if you would allow me. The public does not get to see a lot of what is happening in here. Right now, I'm looking at a monitor, and all that the public can see is me speaking, right? And I need to lose some weight, boy. Or that screen spreading me out, man. Yeah, we got, you know me, I don't like that. The ratio on that screen is wrong. That is stretched, and it is wrong. Madam Speaker, that speaker's at that screen monitor, the proportion is one. It's stretching me out. But all I can see on that is myself speaking and our interpreter. And I want to congratulate and commend them for the work that they're doing, such that those who have impairments in terms of hearing can be able to follow our proceedings. That's all they can see. And that is all that is going to be recorded. So what the member for number 7 was doing was using that in order to get a capture, to make a political point, and then leave the parliament, not to further himself in the discussion, in my opinion, Madam Speaker, in my opinion. And so I want to support the bill before this Honorable House, the Nevis Island Administration Civil Proceedings Bill. I think that it is uncontroversial. We have discussed whether or not we need to spread it out any further, and this consensus is that there is nothing else to debate on this. And so I know that the AG will now come and clear up any other misgivings or misunderstandings that some may have had. With those couple of words, may it please you, Madam Speaker.
Thank you, Honorable Member for St. Christopher 3. I recognize the Honorable Attorney General to do his wrap-up.
May it please you, Madam Speaker. Madam Speaker, I'm very new to this. I'm a proud Kittitian and Nivision. Nivision first. Rice's Village, Gingerland. And today, Madam Speaker, could have been a historic day for the people of St. Kitts and Nevis. It is a day where we're presenting 2 bills that were crafted in collaboration between the Attorney General's office and the legal department within the Office of the Premier in Nevis, for an important reason. And our children could have watched us across the aisle, government and opposition, work together to solve a legislative problem. And instead of history being written as that, history will now be written as people trying to make or get political points out of such an important activity. And Madam Speaker, I'm not a politician. I'm a lawyer. And I want us as a nation to be mature. We are 40 years in this business almost. We want to have mature legislature. We want to debate when things need to be debated. And we want to debate based on substance, not based on political points and propaganda statements. So I want to start, Madam Speaker, by saying and telling the people of this nation that this bill does not change the Constitution. And no matter how many WhatsApp propaganda graphics you receive, those are not the truth. The truth is, Madam Speaker, is that this bill does not add any matters within the exclusive domain of the NIA in the Constitution. What does this bill do, Madam Speaker? It simply changes the Crown proceedings framework to clarify by legislative framework that the NIA, as an organ of the Crown, can sue and be sued with respect to the matters within the exclusive domain. That is why the recitals that one of the members was referred to was in the bill. And I think I have to repeat it, although I thought I summed it up in my initial presentation as to why we were here. the Chief Justice, learned Chief Justice, in her opinion, as she has the right to have, said, the NIA has no legal standing to sue and be sued in civil proceedings, given the applicability of the Crown Proceedings Act to Nevis. That is not about the Constitution. She is saying our legislative framework does not allow or support the NIA to sue and be sued. That is what we're trying to rectify today. And it is a very simple point. The judicial arm of government has adjudged that the executive arm of government has a limitation, which wasn't and therefore must be rectified by the legislative arm of government by way of legislation and not constitutional change. Legislation. The Nevis Island Administration Crown Proceedings Bill. Crown Proceedings Amendment Bill. Those are the amendments and legislative changes to allow the statute law to reflect that the NIA can sue and be sued, because the statute law predated the Constitution. The Constitution did not expressly state it. So there is an open chance that a lawyer, the Chief Justice being one, in her capacity as a judge, can say that the legislative framework does not support this thing. So as the member for number 3 said, our duty is in 2023. How many years that is since 1956?
That's 43, 44 plus 22. That's 67.
67 years later, can rectify that issue. And you have to understand, that statute was done in a time when our state was made up of 3 islands. One state. Since 1983, we are now one federation with a federal government and a Nevis Island administration. So the Crown Proceedings Act from 1956, amended significantly in 1976, does not apply, and we are therefore seeking to rectify this. It is totally uncontroversial. And, Madam Speaker, I don't think it must not be understated. This was a project undertaken by the legal department of the NIA and the Attorney General's office. And is now coming to the House. It is uncontroversial.
And supported by the Leader of the Opposition.
And supported by the Leader of the Opposition. Actually supported by 9 out of the 11 elected members in this House. 9 out of the 11 members of this House are supporting a bill. And now we are being sidetracked in that important exercise for politics. I don't understand it, Madam Speaker. Maybe in more time sitting in here, I might be able to understand it. I just don't understand how country cannot be above self and country cannot be above party. My principle, country above self. Madam Speaker. And those political games are not necessary when we're doing something so historical as this. So historical as this, Madam Speaker. And in my presentation, Madam Speaker, I said the Prime Minister has already triggered a constitutional reform. That constitutional reform committee is going to go from hard times in Gingerland to Upper Monkey Hill, to St. Paul's, to Jessup's. And I just learned the other day that Newcastle is Castle. It's called Castle, not even Newcastle, they call it, the nickname is Castle. 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 And that constitutional reform committee that the Prime Minister and member for number 8 is setting up is then going to do the greatest consultation our people have ever seen, because we have some important decisions to make. And we shall. This is not it. This is not that constitutional reform, you know. This is solving a legislative problem. The constitutional reform will come. And we will not just talk about it, we will do it. And if the Prime Minister allows me to be an integral part in that, I will. Because we're not doing it for us, we're doing it for another generation beyond us. We want to have a robust constitution that lasts at least another 40 years. And Madam Speaker, I think I only say that, and I only get so passionate because this is something I feel strongly about. I feel strongly that you debate when you need to debate, and you support when you need to support, and when there's controversy, you go to the public to talk about controversy. But we're not dealing with a controversial bill, Madam Speaker. As I said, I think it's important because as the member for number 3 said, you don't see a lot when you're watching on TV and on the internet. And I too look very fat, so I'm a little worried about the camera on the screen. But, Madam Speaker, let me make sure you can see it. This is the bill. One page, 2 sides, mostly recitals. But all it does, Madam Speaker, it says the NIA can continue what it was doing 40 years, sue and be sued. And if you want to serve documents on the NIA, you serve them on the legal department of the NIA. And if you want to serve on the officer of the NIA, you serve on the officer. End of story, no controversy. Len Ben story end? Yes. Nothing more, Madam Speaker, nothing less. And Madam Speaker, the next bill. Lead Ben story end. Okay, that's an interesting one. Castle. So, Madam Speaker, that is, and it's probably no coincidence that who's in here is in here right now. The people who are trying to do the work of the people. And let's get on with it. With that said, Madam Speaker, I have nothing more to add. May it please you.
Thank you to the Honorable Attorney General, the mover of the bill, for his wrap-up. The question.
No.
The question is that the bill shortly entitled Nevis Island Administration Civil Proceedings Bill 2023 be read a second time. Those in favor? Aye. Those against? The ayes have it. House moves to committee stage. Oh, sorry, read the question.
A bill to provide for the Nevis Island Administration to sue and to be sued in its capacity as an organ of the Crown and for related matters, otherwise known as the Nevis Island Administration Civil Proceedings Bill 2023.
The bill shortly entitled Nevis Island Administration Civil Proceedings Bill 2023 has been read a second time. House moves to committee stage.
The arrangements of sections.
The question is that the arrangement of sections stand part of the bill. Those in favor? Aye. Those against? The ayes have it.
Clauses 1 through 6.
The question is, you're reading from the track change.
Clauses 1 through 5.
The question is that clauses 1 through 5 stand part of the bill. Those in favor? Those against? The ayes have it.
The enacting clause.
The question is that the enacting clause stands part of the bill. Those in favor? Those against? The ayes have it.
The title.
The question is that the title stands part of the bill. Those in favor? Those against? The ayes have it. House resumes. Honorable members, I think it is this, that we are at a convenient stage in time for some nourishment. I wish to rise for lunch. We can be back in an hour. I prefer to rise for lunch. I prefer to rise for lunch. 1 hour? Or an hour and 15 minutes. It usually takes about that time. So 2:25, 2:20, thereabout. Sorry, let's say 3 o'clock. Let's round it off at 3 o'clock. 3 p.m. House, I will rise and the House will adjourn until 3 p.m.
WINN is 98.9. 98.9 is WIN FM.
Music's finest artists converge in Bastia from June 22nd to June 24th for the 25th hosting of the St. Kitts Music Festival. Hitting the festival main stage will be Skillibeng, Chronix, Coffee, Byron Messiah, Anthony B, Governor, Romaine Virgo, TJ, Valiant. Them boy don't got nobody. Grandmasters, Collision Band, Small X Band, New Vibes Band International, Mr. Bagdal, Akai You Sweet, Preedy, Guess the Band, Ricardo Drew, Patrice Roberts, Skinny Fabulous, Nyla Blackman, Static. Erica Edwards, 313 Family, Gramps Morgan, Nitra B, Ear Supply, Dexter Daps, and Burner Boy. It's the 25th edition of the St. Kitts Music Festival from June 22nd to June 24th at Warner Park. An experience like no other. Tickets are now available at stkittsmusicfestival.com.
Supermarket shoppers understand that convenience matters. At Hortsport's Value Mart IGA, we know that price matters most. Ample parking and the widest variety matter. At Hortsport's Value Mart IGA, we know that price matters most. Clean, spacious aisles and the highest level of customer service all matter. At Hortsport's Value Mart IGA, price matters most. We've renewed our commitment to guarantee the lowest prices in the Federation. Why? Because we understand that in this tough economic environment, price matters most. Shop smart. Shop Value Mart, where price matters most. Farms Estate Nevis and Wellington Road, St. Kitts.
Price matters most.
You found the sound. 98.9. WIN FM.
We now bring you the headline news. The headline news is brought to you by Caribbean Alliance, KDP Enterprises, The Grange, and Caribbean.
When it comes to the important things in life, your health, your education,